August 2, 2023, the Hindu News Analysis. There is a new announcement for today. That is, our channel name is changed from Future IAS Only Reading No Reading Only Understanding to UPSC IAS. Without wasting much time, let us move on into the first article. Table of contents. First article, that is the dangers in the Digital Personal Data Protection Bill. What is Data Protection Bill? The government has introduced the Personal Data Protection Bill 2019 in the Lok Sabha in 2019. However, the bill was withdrawn in August 2022, citing the inadequacy of the provisions in meeting global standards regarding the data privacy. The new bill has been introduced after revamp of the provisions. Next article is IIM, that is Indian Institute of Management. Bill is a bold move. Next thing that we see is the bill seeks to amend the Indian Institute of Management Act 2017, which declared 20 existing IIM as institutions of national importance with a view to empower these institutions to attain the standard of global excellence in the management and management research and allied areas of knowledge. Next article is about what can amended the Forest Conservation Act change. What is Forest Conservation Act? The broad aim of the Forest Conservation Act are to protect the forest and wildlife, act as a check on the state government's attempts to divert the forest land for commercial projects and strive to increase the area under forest. For forest land beyond 5 hectares, approval for diverting the land must be given by the Union Government. Next, Prelims Facts. GI tax given to the crabs from Rajasthan, mangoes grown in Goa. These are the things and more let us see in the upcoming slides. Next one is Lok Sabha passes a bill on birth registration. Third one is Centre owes 6,366 crore in MGNREGS wages to 18 states and union territories. Let us move on into the first article, that is the dangers in the Digital Personal Data Protection Bill. First article that talks about the dangers in the Digital Personal Data Protection Bill, that is government is set to introduce the Digital Personal Data Protection Bill in the Parliament. The final draft is shrouded in secrecy. Last week, opposition members walked out of a meeting of the Parliamentary Standing Committee and submitted the dissent notes, objection to the adoption of the report on Digital Personal Data Protection Bill. They claimed that the bill was neither shown to the members nor formally referred to the committee. That is the issue. Next, let us see some of the basic timeline for this Personal Data Protection Bill. First, in August 2017, what happened is BN Shri Krishna Committee Expert Committee constituted for this Personal Data Protection Bill. And then on July 2018, the committee submitted its reports on Data Protection Framework. On December 2019, the Personal Data Protection Bill introduced in Lok Sabha. In December 2019, the bill referred to the Joint Parliamentary Committee. On December 2021, Joint Parliamentary Committee tables its reports in the Parliament after the extension in the September 2020 and March 2021. In August 2022, the government withdraws the Personal Data Protection Bill, and on November 2022, the government introduces the draft Digital Personal Data Protection Bill for the public comments. In November 2022, Ministry of Electronics and Information Technology introduced a revised bill for the protection of digital personal data, and the bill was titled as Digital Personal Data Protection Bill 2022. This bill replaced the Personal Data Protection Bill 2019. Okay. Next, the core issues of the Data Protection Bill. The Data Protection Bill of 2022 includes the provision to amend the Right to Information Act, which has empowered the millions of Indian citizens since its enactment in 2005. RTI Act includes a provision to harmonize the people's right to information with their right to privacy through an exemption clause under Section 8, Class 1 and Class J. Personal information is exempt from closure if it has no relationship to any public activity or has no relationship to any public interest, or if information sought is such that it would cause unwarranted invasion of the privacy and the information officer is satisfied that there is no larger public interest that justifies the disclosure. Personal Data Protection Bill 2022, however, proposes the amendments to Section 8, Class 1, Class J to expand its purview and exempt all personal information from disclosure. This threatens the very foundation of the transparency and accountability regime in the country. Given that the government is the biggest data repository, the effective data protection law must not give wide discretion powers to the government. Personal Data Protection Bill 2022 unfortunately empowers the executive to draft rules and notifications on a vast range of issues. For instance, the central government can accept any government or even private sector entity from the application of the provision of the law by merely issuing a notification. This would personally allow the government to arbitrarily exempt its cronies and the government bodies such as UDAI, resulting in immense violation of citizens' privacy. On the other hand, small non-governmental organization, research organization, associations of persons and opposition parties that the government choose not to include in the notification would have to set up the system to comply with the stringent obligations of a data fiduciary. Let us see about the autonomy. There is no autonomy. The draft bill does not even make a pretense of ensuring the autonomy of Data Protection Board, the institution responsible for the enforcement of the provision of the law. Central government is empowered to determine the strength and composition of the board as well as the process of selection and removal of its chairman and other members. The chief executive responsible for managing the board is to be appointed by the government, giving it direct control over the institution. Let us see some of the key features of the Personal Data Protection Bill. Data principle and data fiduciary. What is data principle? Data principle refers to the individual whose data is being collected. In case of children, their parents or lawful guardians will be considered as their data principals. Data fiduciary. Data fiduciary is the entity which decides the purpose and means of processing of an individual's personal data. Personal data is any data by which an individual can be identified. Processing means the entire cycle of operation that can be carried out in respect of the personal data. Let us see some of the 7 principles of the 2022 bill. The personal data by organization must be done in the manner that is lawful, fair to the individual concerned and transparent to the individual. Secondly, the personal data must only be used for the purpose for which it was collected. Third principle talks of data minimization. Fourth principle puts our emphasis on the data accuracy when it comes to collection. Fifth principle talks of how personal data that is collected cannot be stored perpetually by default and storage should be limited for a fixed duration. Sixth principle says that there should be a reasonable safeguard to ensure there is no unauthorized collection or processing of the personal data. The seventh principle states that the person who decides the purpose and means of processing of the personal data should be accountable for such processing. Let us see the rights of the individuals. Access to information, right to consent, right to erase, and also right to nominate. Let us see about Data Protection Board. The bill proposed to set up a Data Protection Board to ensure the compliance with the bill. In case of unsatisfactory response from the data fiduciary, the consumer can file a complaint to the Data Protection Board. Let us see how has India strengthened the data protection regime. Justice K.S. Puttasamy vs. Union of India 2017. In August 2017, 9-judge bench of Supreme Court in Justice K.S. Puttasamy retired vs. Union of India unanimously held that Indians have constitutionally protected the fundamental right to privacy that is an intrinsic part of the life and liberty under Article 21. And also B.N. Sri Krishna committee is also on 2017 is also appointed for the data protection. And also the IT rules 2021 mandates a social media platform to exercise a greater diligence with respect to the content of their on their platforms. Next one, what the data protection bills are there in our nations are European Union model, US model, China model, and also let us see some of the Prelims point of view, that is right to privacy, which is protected under the which article of the Constitution of India that is related to this article, that is Article 21. In Puttasamy vs. Union of India case, the right to privacy was declared as a fundamental right by the Supreme Court. Right to privacy is protected as an intrinsic part of the right to life and personal liberty under Article 21 and as a part of freedom guaranteed by the Part 3 of the Indian Constitution. Privacy safeguards individuals' autonomy and recognizes one's ability to control the vital aspects of his or her life. Privacy is not an absolute right, but an invasion must be based on legality and need proportionality. Let us move on into the next article, that is IIM Bill is a bold move. In this article, let us know what is the context. In 2017, Parliament passed the Indian Institute of Management Act, and the act, which hugely expanded the autonomy already enjoyed by the IIMs, contains an important clause. It requires the Board of Governors of the IIMs to commission an independent review of the institute at least once every 3 years and place the report in the public domain. Let us see in the larger picture. 6 years on, every few of the 20 IIMs have done so. Among the top 4 IIMs, only review report of IIM Bangalore is available on the website. This act of omission gives us an indication as to why the government thought fit to table the IIM amendment bill in the parliament last week. No government can take kindly to non-compliance with the act of the parliament. In 2023 bill seeks to take back from the IIMs the power that the government ceded in 2017. The government seems to have judged that the dangerous governance vacuum has been created in the IIM systems in the years since it relinquished control over these institutions. IIM Act created a situation where there was no meaningful checks and balance on the directors. The absence of norms on key matters such as appointment of dean had been evident even in the years leading up to IIM Act, as the government increasingly adopted the handoff approach. Act served to worsen the situation. The bill 2017 legislation actual context talks about the bill proposes giving the government an expanded role in the appointment and removal of IIM directors and initiating inquiries. Current law 2017 Act granted the IIMs greater autonomy by declaring them institution of national importance. Current IIM Act allows the institutes to be run by their board of governors, which has the power to make policy decisions related to the administration and the functioning. All the key appointments of the chairperson, board members and the director and the chairperson of the coordination forum of the IIM were left to the BOGs. The government reduced the presence of central and state government on the board from 4 members to 2. The 2023 bill seeks to undo many of the provisions of the early act. It creates the post of visitors, the President of India. The visitor will appoint the chairperson of BOG, one nominee on selection committee for the director, and the chairperson of the coordination forum of IIMs. Let's repeat, because it's most important point that was given, that is the chairperson of the coordinator forum, one nominee on the selection committee for the director. He or she will also approve all the director appointments. Visitor can initiate any review or inquiry into the affairs of an institute and remove the director on his or her own. Let us see some of the significance of this IIM Bill 2023. The motivation behind the bill is the government's dissatisfaction with the IIM's responsiveness and governance issues, turbulence within the IIM system, including conflict over decisions and internal dynamics, lack of checks and balance on the director's authority under 2017 Act, rise in MBA courses fee without proportionate justification. Comparative analysis: the private US universities board effectiveness is attributed to the factors like endowment, research, funding, and competitive environment. The government control in the educational institution as seen in Californian system and the IIT hasn't hindered their global prominence. IIMs flourished under the government control with operational autonomy for several decades. Government's intention is to seeks to restore the accountability and oversight in the IIM system. 2023 bill aims to address the lack of checks and balance and enhance the democratic accountability, and ensuring the accountability to the government and parliament is seen as preferable to the unchecked autonomy. Let us move on to the next article, that is what can amended the Forest Conservation Act change. What is the context? The controversial Forest Conservation Amendment Bill 2023 passed by Lok Sabha with a limited debate awaits discussion in the Rajya Sabha. The bill aims to restrict the conservation scope, exempt the borderlands for strategic projects, and allow some non-forest activities. Let us see the amendments. The Supreme Court judgment in 1996 has reiterated such a broad application. It said that a forest includes all lands recorded as such in government records, regardless of ownership, as well as deemed forest, which are not officially classified as forest, but satisfies the dictionary meaning of the word, any large area with significant tree cover and undergrowth. The court has also asked the states to undertake as exercise to identify and notify their own deemed forest. The bill stipulates that only those lands that were notified as forest under the Indian Forest Act 1927 and any other relevant law are recorded as a forest in government recorded records will acknowledged as a forest under this act as well. And this revision stands in stark contrast to the wide applicability of the extent act at present. Amendment as such, the amendment opens up all the lands that hasn't officially recorded as forest to commercial activity. It also removes the checks and balances the act currently includes in the form of forest clearance permissions and informed consent of the local community. The bill seeks to exempt the linear infrastructure projects like road, highways from seeking forest clearance permissions if they are located within the 100 km of the national border. The experts have raised the concerns because a strategic linear project of national importance is an undefined term. Strategic linear projects of national importance is an undefined term and can thus be misused to push through infrastructure projects that are devastating our local ecology. Let us see some of the implications. The concerns with the classification of land as forest that we had seen, and the controversy over exemption of the border infrastructures. Forest Conservation Amendment Bill 2023 aims to remove the linear infrastructure projects such as roads and highways from obtaining authorization to destroy the forest if they are located within the 100 km of the national boundary. Concerns flagged by Joint Parliamentary Committee. Despite receiving criticism from the tribal organizations, environmental attorneys, conservationist, activist, and citizen organizations, joint parliamentary committees did not suggest even one amendment to the bill in their report. The concern about the amendments' effect on the community rights contained in the Forest Rights Act 2006 were also expressed by the Ministry of Tribal Affairs. Next, moving on into the prelims facts. First one is about GI tag. It is given to the Rajasthan crafts, mangoes grown in Goa. 7 products across the country, including 4 from Rajasthan, were given. Let us see one by one. Geographical identification tag by Geographical Indication Registry in Chennai. Jalisar, the 2 silp metal craft, Goa Mankurad, mango, Guan Bebinka is a type of pudding, a traditional Indo-Portuguese dessert. It is also known as Queen of Goan dessert. Udaipur Koftgari metal craft, Bikaner Kashida curry craft, Jodhpur Bandage craft, Bikaner Ustakala craft. Next, prelims factors. Lok Sabha passes the bill on birth certification that paves the way for the digital birth certificates, which will be a single document to be used for admission to the educational institutions, application for driving licenses, government jobs, passports or other voter enrollment, and registration for marriage and others. Let us see about that. Like, what are the key features of this bill? The bill introduces significant amendments to the Registration of Birth and Deaths Act 1969. That provides for the appointment of a Registrar General, India for issuing a general direction for registration of births and deaths, creates a national and state level database of registered births and deaths, which would help in updating other database. The bill make it mandatory for states to register births and deaths digitally on a centralized portal called Centers Civil Registration System (CRS). The medical institutions will be required to provide a certificate stating the cause of death to the registrar. Let us see the applicability. Digital birth certificates will be issued for the admission. That we have seen it. Let us see some of the benefits. The centralized registrar will facilitate the efficient and transparent delivery of the public service and social benefits. The database will also update the national population register and ration cards and property registration records. It will also simplify the registration process for adoption, orphaned, abandoned, surrendered and surrogate children. Next one is the bill aims to eliminate the need for multiple documents to prove the date and place of birth. Date registration for birth and death Amendment Bill 2023 proposes to create the digital birth certificate that will serve as a comprehensive document for various purposes. Okay, next article that we are moving into is Center owes 6,366 crores in MGNREGA wages to 18 states and union territories. Union Rural Development Ministry informed Parliament on Tuesday that it owed 6,366 crore under the wage component of Mahatma Gandhi National Rural Employment Guarantee Scheme to the states. There are total 14.42 crore active MGNREGA workers, most of the women dependents on wages to supplement their family's income. Of the total, 2,770 crore is owed to the West Bengal alone, invoking Section 27 of Mahatma Gandhi National Rural Employment Guarantee Act. The center has blocked the payment of over 7,500 crore to the West Bengal for non-compliance of directives of the central government since December 2021. And let us see the key objectives of the scheme. MGNREGA, generation of paid rural employment of less than 100 days for each worker who volunteers for unskilled labours, proactively ensuring the social inclusion by strengthening the livelihood base of the rural poor, creation of durable assets in the rural areas such as wells, ponds, roads and canals, use urban migration for rural areas, create rural infrastructure by using untapped rural labour. The following eligibilities are: must be a citizen of India to seek MGNREGA benefits. Job seekers have completed the 18 years of age at the time of application. Must be a part of the local household. The application must be made with the local Gram Panchayat. And the applicant must volunteer for unskilled labour. Key facts related to the scheme. Ministry of Rural Development, Government of India is monitoring the entire implementation of the scheme in the association with state government. Individual beneficiary oriented work can be taken upon the costs of SC/ST, small and marginal farmers, beneficiaries of land reforms, beneficiaries under the Indra Awas Yojana of the Government of India. Within 15 days of submitting the application from the day of work is demanded, the wage employment will be provided to the applicant. Right to get unemployment allowance in case of employment is not provided within 15 days of submitting application or from the date and when the work is out. Social audit of MGNREGA workers mandatory, which leads to the accountability and transparency. Gram Sabha is the principal forum for wage seekers to raise their voice and make demands. It is the Gram Sabha and Gram Panchayat which approves the shelf of work under MGNREGA and fix their priorities. Let us see some of the mains practice questions. The amendment to the IIM Act raises concerns over the autonomy of the institutions and the governmental oversight. Comment in the 150 words for 10 marker. What are the implications of the amendments to the Forest Act? 150 words, 10 marker. That's all. Try your comments in the comment section. And finally, thanks for watching. Have a nice day.